Great. So today we're going to go over modules 7 and 8. This is also expanding on supporting families through complex systems. Quite a few of our modules are in this module section here for the being able to kind of supporting families through, law enforcement, court assistance, the medical examiner's office, referrals, things like that. So all the different systems that a lot of families and victims will go through when they find themselves in an MMIP situation. The modules focus on the knowledge and practical tools needed to navigate families through the complex systems following an MMIP or suspicious death case. We really are going to focus on transparency, advocacy, and trauma-informed system navigation. And Module 7 is working with the district attorney's office. And it's going to be understanding the role of prosecutors and how families can engage with the DA's office. So 4 core things we're going to learn today will be explaining the role of the district attorney during a criminal case, being able to describe how charging decisions are made, which will be really helpful when you're talking with victims or surviving family members, because that can be really confusing for them. And then helping families communicate effectively with prosecutors and victim witness coordinators. Sometimes they're called victim witness paralegals. It will depend on your court system, but it'll be under one of those 2 names here in Alaska in the state court. And then set realistic expectations when cases are delayed or declined, which is sadly going to, happen quite often. So what does the district attorney do? The district attorney represents the state, not individual victims. And I add that in there because a lot of victims or surviving family members, when there is an open criminal case for, let's say, like a homicide situation, they do have victim rights. The surviving family members have the same victim rights as a regular victim. And sometimes that can be confusing for families and for victims because they are under the impression that the prosecutor is representing them in the case against the defendant. And that can bring sometimes a lot of confusion and frustration when the prosecutor kind of does things that the victim or surviving family members don't agree with, because their kind of mindset is like, well, you're representing this case and you're representing me. And that actually is not the case. When it comes to state courts, the prosecutor is actually representing the state of Alaska, and they include victims and surviving family members because that's the law for them to have to include them. And they do have a lot of communication, or I shouldn't say they do. They should have a lot of communication with the victims and surviving family members, but there is a clear line, and we'll kind of go through that as we go later through this module. And so I always like to tell victims or families pretty soon, maybe in the first 3 meetings that I have with them, if there's a criminal case, I like to have that thorough explanation for them so that they understand moving forward that they're not in a case against the defendant. It's the state of Alaska in a case against the defendant. And so it hopefully kind of makes them understand some of the things that happen later on through the case, and hopefully is a little less frustrating to them so that they go in knowledgeable about that. So some of the responsibilities for the district attorney, I'll also say ADA, so the assistant district attorney, or the DA, which is district attorney. The district attorney is who's like heading your court, and then your ADA is most likely who you're going to deal with the most if there's a criminal case. So they're your regular prosecutors in the case. Very rarely does the district attorney themselves get involved to a point where you're, as an advocate, meeting them, or the victims or surviving family members are meeting them. It could happen, but it's not very common. Usually, you will be in contact with the ADA for the case, or the prosecutor. So their job is to review evidence submitted by law enforcement. So law enforcement, in some of the other modules we had, I explained, kind of gathers everything and evidence-wise, and then they turn that over to the DA's office to make a decision. So they're reviewing all that evidence. They're determining whether charges can legally be filed. They have to, in order to have a criminal case filed, the DA's office has to feel that they could 100% win that case. So it has to be, when you hear the saying, beyond a reasonable doubt, that is pretty much a basic saying of, if they have any inkling as a prosecutor that this case couldn't win, for whether it's lack of evidence, lack of, suspects, or, whatever it could be, they won't move forward with charges. So that's kind of where they're at with determining, can these charges be filed? And then they will file the criminal charges if they determine that there is enough evidence to win that case. They prosecute the criminal cases in court, as representing the state. They can negotiate plea agreements. So sometimes things go to trial, sometimes they go through to a plea deal. It really depends case by case, but it would be the prosecutor who, if there is a plea deal negotiation, it's the prosecutor who's doing that. And they also prepare witnesses for court, which sometimes that can be the victims or the surviving family members themselves, depending on the case that the prosecutor has put together. So if a victim is still alive, they would most likely be testifying in court, and so they would be prepared as a witness. If a surviving family member had information that was relevant to proving the case, they would most likely be called as a witness as well. And so the prosecutor would be prepping them basically for that time when the time comes. And then they seek justice while following legal and ethical obligations. And I make, that statement there to just kind of say a few things. Sorry, guys, I'm a little stuffy, so sorry if I sound bad, but when we think of justice, generally we're thinking of criminal justice. Most people, when we think of that, we're thinking of jail time, prison sentences, things of that nature. And that, of course, is one way to seek justice. I always tell people there's a variety of ways that families and victims can seek justice. For this particular way of seeking justice, the prosecutor does have to follow, of course, legal statutes, and be very sure that they're going to win a case, and have very ethical standard, like high standards also. And that can become complicated sometimes for victims and surviving family members, because it's, we're everyday people. We're not attorneys. We might not always understand like why something is or isn't being done. And a lot of the times there is usually like a legal or ethical reason behind it for prosecution. And so it's just that we don't quite, even it hasn't been explained to us, it's understandable that we don't, know what it is. So I always tell anybody who's working with victims or surviving family members that if you run into a situation where you feel like something's kind of wrong or it doesn't feel right, um, always try to make a meeting with the prosecutor's office, with the ADA who has the case, so that they can explain why they're making those choices. And a lot of the times you're going to find that they are for legal and ethical reasons. So what the DA does not do, so it doesn't conduct most investigations. That is what law enforcement is doing. They, of course, do work, hand in hand with law enforcement, but the actual, investigation part is generally always left up to law enforcement. Um, they are supposed to represent the family's personal interests, and that is due to victims' rights laws. So they don't work for, like I said, they don't work for the family or the victim. They do have to include them, and they should be considering the family and the victim when certain things are happening. They should be open to having conversations with the family because it is one, it's the victim, right? And two, it's just kind of part of the way the system operates. It or should. And I always do should because there's never a solid like this will always be the case. Sometimes it isn't. So, and not because it's the victim's rights don't matter. It's just sometimes things don't get followed the way they're supposed to. So that's kind of also where we would come in at times if we're working with victims is to ensure that those things are happening. And then they can't guarantee that charges are going to be filed. That's a big one when there's like an open investigation with law enforcement, and there is usually still the DA's office is somewhat involved. Charges haven't been filed yet. They're, kind of looking at what's been given to them, and families really are adamant that charges have to be filed. Um, and what you'll often hear from a district attorney's office is like, we can't tell you for sure yet, or we, can't give you an answer yet. And it's just because they can't make a guarantee. And they also can't make a guarantee that certain charges will be filed. So something could be clearly a homicide situation, and they may go for a lower charge, like let's say manslaughter versus a higher charge. And so those are just kind of things to keep in mind when you're, dealing with the district attorney's office is there's never any guarantees. There's never really any promises. They ethically couldn't make them. And then there's also never a guarantee of a conviction. You know, shouldn't ever hear a prosecutor say, we're going to win this case. Now, they might tell you as the advocate separately away from the family, I feel really good about this case, or I think we've got a really good shot here. A lot of the times they're not going to say that in front of the families or the victims because there's never a guarantee, and it would really affect the victim or surviving family members deeply, to have that expectation and then to be let down. So ethically, they really shouldn't be doing that. Generally, I I don't see that happening. Sometimes, like I said, in private conversations with them, they might say it, especially once you get to know the prosecutors in your area and you're pretty comfortable with them professionally, they may say, I feel real good about this case. I think this is going to go to trial. But that would be something that kind of would be something you were told, and I would never tell that to a family or a victim unless it came directly from the prosecutor themselves, like in a meeting where we were all together. And then they also cannot share every investigative detail. So kind of very similar to like when law enforcement has an open case, when there's an open criminal case, it is much the same in that they've built a case. Some stuff the family or victims can find out. For the most part, though, it's kept under wraps. And that is for a variety of reasons. I would like, and like I said, I'm not an attorney, just kind of in my experience with talking to prosecutors and being kind of nosy as to why things are the way they are. Uh, you know, it seems that they're building a case and they don't want any potential information to get out, even if it was by accident and for somehow it to get to the defense, right? Because it could have an effect on their their case that they're building. So they really have to keep things under wrap, and that is very normal. So if you see that in a criminal case, don't be surprised. It's not that they're trying to hide something necessarily. It's just part of the, uh, normal process. So how charging decisions are made. Before charges are filed, the prosecutor is going to review police reports, witness statements, physical evidence, digital evidence. They're also going to talk with the medical examiner and look at the findings, so the autopsy, also toxicology reports. They're also going to look at any laws. So, depending on the charges that they're considering, they would look at the laws that would go towards that charge to see if everything falls in line with that charge, what they have. Would it apply? Does it all flow, basically? Um, and then, of course, whether evidence meets the legal burden of proof, which is that they have to feel that they 100% could win this case. Um, it's like with beyond a reasonable doubt. So all those things are what they're going to be looking at before they're going to actually decide if charges will happen and what charges will be brought against the defendant. And then charging decisions to consider. So some of the things that, when you're talking with families, when you're talking with victims, and they're kind of questioning why. One, I don't generally like to answer questions for the prosecutor's office. Like, I try not to ever do that. But if they're very general things, I feel comfortable, answering that. And so, kind of what I just went through with you, I would feel comfortable telling a client, this information, like, hey, this is what they're looking at. Um, and then I would also, feel comfortable saying, here's some of the things that they have to consider is like, is there enough admissible evidence? Um, can the elements of the crime be proven, with the evidence that they have? Are additional investigative steps needed? So sometimes, what I'll tell families, if the prosecutor is saying we haven't made a decision yet and we're still looking, that is usually meaning that they're still seeing if maybe there's additional evidence that law enforcement has or can find. So um, that can put a little bit of pause on the charges coming forward. But it is not saying that there won't be charges. It sometimes means that they have to gather more, not, well, they'll, not the prosecutor, but law enforcement gathering more evidence. And that sometimes takes a little bit of time. And then, is there also forensic testing pending? So if they're still waiting on particular, like toxicology reports is a big one. So we're better about it now than we have been in years past, but a lot of testing, especially specialized testing, we still send out of state. And so they have to wait until that report gets back to them before they can actually review that report fully and then make a decision about charges. So if you talk with the prosecutor and you have a meeting with the family and they're saying, yes, we're still waiting for, a one of the final medical examiner reports, that usually just means they got to see that final report, and that could make or break moving forward with the case. So any of these things, I would feel comfortable, having a conversation with a victim or family member about. If it went deeper than that, like if they said, well, what exactly, type of test is this? Like, what is this testing for? How long does it normally take? Like, they're wanting more detailed stuff that I would not go into further. I would say, well, let's see if we can make an appointment with the prosecutor's office so you can have, like, further questions answered about these things. So very basic stuff. Like I said, if you're comfortable, and if you find yourself after a while kind of getting knowledgeable in these things, I think it's okay to have those conversations with victims and certain family members. Deeper stuff definitely put off to the prosecutor themselves, because we don't want to give wrong answers, of course, to families and victims. And so the victim witness, paralegal, or coordinator, so it'll be one of the two, depending on where you're at, they are on almost every criminal case. You will have a victim witness paralegal if it's a violent crime. So it kind of sounds a lot of times like just wait, their job is like a lot of times people feel like, oh, well, they're kind of like advocates, right? Um, to some extent they can be. It's super limited though. What their real job is to support the prosecutor, like as a paralegal, and also to kind of be the middleman. I call it, yeah, they're the middleman between the family, you, and the prosecutor. So a great example is, I had a case earlier this week. I had a question for the prosecutor about a hearing that was coming up. I normally am not going to send an email directly to the prosecutor. I will send that to the victim witness paralegal. If it, if it's just a basic question that I think that they could answer, or that they'll find out from the paralegal and give that answer to me. So they're kind of that middleman. They are very useful for you as an advocate, or if you're working with, these families, to get to know them, to try to, build just professional relationships with them, because they will be a huge help sometimes. If you cannot get a hold of of a prosecutor, you're you're most likely the first person you're going to get a hold of is the paralegal. And so they can really be somebody who makes your job easier sometimes in just kind of getting information, or giving information and getting it over to the prosecutor. So the things that they will often do, and I also like to explain, like, not every victim witness paralegal does these things. It really depends on the person. It depends a lot on how long they've been at the court doing these jobs. It depends on sometimes personalities. These are within their job descriptions, what I have here, but I don't want to set the expectation for you all that these are definitely going to be the experiences that you'll have with them, because it is not always the case. But it is good to know that this is what they are supposed to be doing. So they should be able to explain the court process to victims and surviving family members, particularly if like a hearing is coming up that the client is wanting more information about, like what's going to happen. Will the defendant be there? Will the defendant's family be there? Things of that nature. They should be able to get those answers and explain them over to the client. And then they are all supposed to notify families about hearings. That doesn't always happen. A lot of times what I've noticed is that they will just ask them to sign up um, for the notification process. There's an online notification process where you could get emails and text messages about hearings. So they'll just ask them to sign up for that, and that'll be how they like notify families, is to try to make sure they get on that list to get notified. So generally speaking, they're probably not going to call at every hearing or before every hearing, unless sometimes it's like a big one. If it's a change of plea, if it's a trial, the big hearings, yeah, they probably will reach out. And then they will coordinate meetings with prosecutors. So kind of like I said earlier, if I have questions or I want to set up a meeting with the prosecutor, I generally do not go straight to the prosecutor with, like, I don't email them directly. I email the victim witness paralegal asking if we can set up a meeting. And then normally they will facilitate that meeting process. And then they also can explain victims' rights to a certain extent. They're not the same as the Office of Victims' Rights attorneys and paralegals. They, you know, they have like more limited knowledge, but they can give basic victim rights information. And so I would definitely say if you had a question, you could ask them and they should be able to answer. And if they can't, then I would go straight to Office of Victims' Rights, which OVR, and they will 100% be able to answer your questions about victims' rights. And then they can also provide referrals for supportive services. So another good thing to do if you guys want to kind of build that relationship with them is see if you can get a meeting with the with the district attorney's office to let them know that you all offer whatever services that you offer. They, and not every court, most do, will keep this information, like referral information. So if you can get yourself on that like list that they have, it's usually an internal list, is my understanding. Then the victim witness paralegal will know, oh, I can refer, this client over to you guys. So definitely see if you guys can get on there for all of the services that you provide, because they can, not just refer out for like advocacy services, they can refer out for substance use, behavioral health, housing. I mean, all these things, they should be able to provide referrals. And then they can answer many procedural questions. So definitely not as well as a prosecutor is going to, but they can still answer some very basic like procedural stuff about what's going to happen at a hearing. They can explain what that hearing is, and they can usually explain what the victim or surviving family member can expect to see in that hearing, especially specific to their personal hearing, like not a generality. They can, because they know the case, they can be a lot more specific in, you know, for example, there is a discovery hearing happening. They would be able to tell the victim or surviving family members, that this is just going to be a quick hearing. They aren't expecting much to happen, and defendant is going to be there, not in person, but over the phone from, wherever he's incarcerated at. So those kinds of things, you can get more detailed stuff from them. Um, and they should be able to, like I said, answer all of these things. It does vary, though. Another thing I like to kind of put out there is that our state, where our court system is always really understaffed. It has been for a long time. And a lot of these victim witness paralegals are holding hundreds of cases they're working with different attorneys and they're holding hundreds of cases. So that's also can be sometimes why you won't get, I don't want to say the best service, but it could be why they're not as active in cases. If they are one person with, let's say, 200 caseload, it, I'm not making an excuse for that by any means, but just to maybe like give some insight on why you might see some of your victim witness paralegals like lacking a little bit. It could be that they're new to the job or that their caseload is super high and they're just having a really hard time managing that, which is also, a good thing to have, like I said, having those professional relationships with them, because you guys can, if you get to know your paralegals there, you can kind of know their different personalities, how they handle cases, and you can know as somebody who's also helping the family, okay, here's where I need to fill in the gaps, right? I know if this paralegal is on the case, this is what they're great at. Maybe this is stuff that they're not so great at. This is where I'm going to have to pick up the slack a little bit. So it definitely takes some time working with people there, getting to know them a little bit professionally, but it is a good resource to have, you know, especially when you're trying to get in contact with the prosecutor. So communicating with the DA's office. So we always want to encourage families to do several things, right? It's really, for me, I feel like as an advocate, I facilitate a lot of stuff for families and for victims, but I want to really empower my clients to feel like they're in the driver's seat, right? Even if they don't know what's kind of going on or they're a little confused about what's happening, I want them to have some feeling of control of what's going on in this case. And so here are some things that I, encourage families and victims to have and do so that they can feel like they have some control over what's going on. Because it feels very much out of their control. Like these cases are long, they're hard, and they're complicated. And so little things can really help people um, feel not so upset as they're going through the process. So we always want to write down questions before meetings. Uh, that's a big one. I think I probably have said that several times now, but it is really important, and it really helps them to know what they're going to ask when they get in that meeting. Because once they get in that meeting, things can just, they evolve, other topics come up, things get sidetracked, and things can get forgotten. And so I don't want my clients to leave a meeting and then the next day have like two or three questions that they didn't ask because they forgot, right? Which is normal. I mean, they're going through a lot and they're overwhelmed, and it's normal to forget. So the way we can get around that is to write down our questions. I also like them to keep track of like any important dates or information as the case, goes through. So I have two things that I give clients when they have a criminal case with me for no, like record keeping. So one of them is a journal I give them to write kind of their feelings and things like that. And that's more to be used for victim impact statements later. And then the other notebook that I give them is to write down like court specific stuff. So tracking dates and information, tracking notes for each hearing, because some families and victims want to attend each hearing, places to write down questions along the way, to talk with prosecutors. I can, after this, I will put some of the templates I use in the Coursify Me so you guys can see what that notebook looks like, and just kind of maybe give you guys some brainstorming ideas there if you want to provide something like that for your clients. But it is super helpful because then they have kind of everything in one place. And then always requesting clarification when legal language is confusing. So a great example of that is a plea deal comes before a client, right, for them to review. It's going to be offered to the defendant. Everything in that plea deal is complicated. Reading it is a lot of words that we're not used to seeing, or, a lot of descriptive factors that we most likely don't know. And then, so for that, it's, super overwhelming because they already are possibly not even wanting a plea deal, and it's probably going to go through. And also, they don't quite understand the documents before them. So when that happens, asking the ADA, can you explain this, whether it's through a meeting or whether it's through an email? Like, what do these things mean? Using plain language with clients, or even if you're in a meeting with the ADA and the client and it's sounding complicated, like the things that the ADA is saying, I will sometimes, say, oh, do you mind explaining that like a little easier for us to understand? And normally I've not ever had anyone have an issue with that. The prosecutors usually have no problem kind of bringing it back down to like regular people speak. But we do want to always make sure that the client knows what is being said to them and understands what that, what's being said, because it could very easily become that they're just confused. They don't know what these things mean. And sometimes some people don't feel comfortable asking, especially in the moment, to have something clarified for them. And so that's a lot of times where we can come in and step in and help them a little bit there. But I also, always tell clients before we go into meetings, like, hey, please don't be afraid to ask if something's confusing. I like to make it feel better and say sometimes I don't know what they're saying either. I usually do, but but it makes them feel better because I don't want people to feel like afraid to ask, right? Afraid to not know. I don't want that for anybody, and kind of breaking the ice a little bit that way can help too. Um, they should also be comfortable asking what happens next. And sometimes you'll find prosecutors that don't maybe want to explain that fully to clients because I don't know why. I couldn't always put say exactly why that is. Maybe they just feel it's not important or it's too complicated. I don't know. But in any case, they should be able to ask what is happening next and have a thorough explanation of that. They have the right to know what's happening. And part of that is after this hearing, what is the next hearing? What does that hearing look like? What does it mean for us? They have the right to those things. Um, we want to also have them to understand that we have to respect investigative limitations. So, and this is a complicated one because there will be things that families and victims don't quite understand, like why this is happening or why this can't be done a certain way, like how they would like it to be done. And there are obviously, there's limitations, there's legal limitations. And so I always like to tell families and victims ahead of time some of those things, or even after a meeting, bringing up some of the statutes maybe that were brought up, and having them be able to read that themselves as well, because I understand how unfair that can feel when the families are being told these things, um, but it doesn't change the fact that it's the law. And I don't say it that way because that's a very insensitive way to say it, but I mean, as I'm just explaining it, like that is just the reality, right? Is like there's the law and there is limitations to the law. And we, all oftentimes are the ones who have to hear the disappointment from the families and victims on that. Um, but I also like to prepare them to that this, you know, could happen. A good example is if a family doesn't like a plea deal that's being offered, it is hard and it is, not a great feeling as an advocate to have to explain to the family that it doesn't really matter if they like the plea deal or not. The def, if the defense accepts it and the prosecution goes forward with it, that's the law, right? It is the way it is. It it doesn't feel good to say that to families or victims who don't, want to go to a trial. But it is a reality. And so even before a plea deal meeting with the prosecutor, I will explain that to the client that, hey, here's the law around this, in plain language. They can move forward if they want. There's also something they can do later, which I'll explain a little later on that, so I won't go too much into it, but to voice their disagreement with it to the judge. But as far as like telling the DA or the ADA, like, no, I don't accept this plea deal. I don't want you to go forward with it. No, the prosecutor, it doesn't matter if they want to move forward with it, right? They can. So those are the things where having those conversations beforehand, letting them know the limitations beforehand, can sometimes soften that blow a little bit. They'll still be upset, they'll still be frustrated, but at least they'll be informed. And hopefully, the way that I like to see things is, did I prepare them a little bit, right? I can't fix everything, but maybe I can help prepare people, is kind of how I look at things. And that's kind of my goal a lot of times with clients, that when we're dealing with hard situations. And then, they should also feel comfortable to follow up if updates are delayed. I will often follow up for families. I always give them the option to like have me be the one to, facilitate these things if it's too overwhelming or they don't, they just don't have it in them in the moment to do it. But I've had plenty of clients who they are very active in these cases, the criminal cases of their loved ones, and they want to, they want to be part of what's happening. They don't want to be on the side. They want to actively participate, and I encourage that. I think, if a family or a victim is up to that, 100%, I love to see it because it gives them a sense of power in a situation where they have limited power. So they absolutely should and could follow up with the ADA and the victim witness paralegal about any questions, any things that are not being answered themselves. If they don't want to themselves and they say, hey, can you do it for me? Of course, like I said, I would do that. I have no problems doing that. Um, but yeah, they're one of those families that are like, we are going to be part of this. Like we want to be 100% in. I say, take the lead. I'm here as your backup. Um, so some good questions families can ask at these meetings or through email if they're emailing the uh, victim witness paralegal or prosecutor. Um, what stage is the case in? So, like I said, sometimes even if I'm explaining what the process looks like, they want to hear it directly from the prosecutor, which I think is completely fine. And, absolutely, they should feel comfortable asking that. So if they want to know from the prosecutor's, own words, here's what's happening, they should, that's a good question to ask. What's going to happen next so that they kind of can prepare. Are there any additional reports still pending? So throughout the criminal case, even towards the end, there may be reports that are pending, not for like toxicology or medical examiner, things like that, but um, we have pretrial sentencing reports that usually happen towards the end of a case. So those are reports that could still be pending. And it would be good for the family or victim to know that information so that they, one, could then ask, what is a pretrial sentencing report, and get that rundown of what it is. And also so they know if something's like kind of holding things up a little bit because that could be what holds up the next hearing if they're still waiting on the pretrial sentencing report. And then what should we expect over the next few months? Perfect question for them to ask, what should we, should we expect to see more hearings that are discovery? Should we expect that you're going to offer a plea deal? What do you think as a prosecutor is going to happen next? What do you feel in this case? And it's good for the families to ask that directly too. And then in the very beginning, this is one that I always have them, either they ask or I ask is, how are they going to receive updates? Because it does then hold the ADA and the paralegal kind of accountable to being sure that they are giving updates. So if the paralegal says, I'll update you, every 2 to 3 months, then the family or victim has heard that and that's the expectation they have. And then if that does not go that way, if it doesn't go that way, that's where we can then follow up. But usually that'll be one of the first questions I will, encourage a family to ask or have on their list of questions. So that way the prosecutor and the paralegal understand that this family wants updates. They want to know what's happening. So why some cases are declined. And this is just some. There's more than this. These are more of like the basic ones that I, have experienced and seen in doing this work. So, a case can not move forward for a variety of reasons. One of them is there is insufficient admissible evidence. And I put admissible there because there could be tons of evidence that, the family knows about, but it's not admissible evidence. And admissible means that the court will accept it, basically. So if the court's not going to accept that evidence for the case, it's not admissible. it doesn't matter that it exists in the way that for this case, right? It matters that it exists. It just doesn't matter for the court case. And so if there's not enough of that admissible evidence to move forward, that's that beyond a reasonable doubt, you know, thing that they got to have before they can move forward. That's where that comes in most of the time. Um, Sometimes families will have questions of, well, why, when I saw all, uh, oh, sorry, you all?
I'm sorry, my thing just decided to show its hands.
Oh, okay. No worries. Um, but yeah, for, um, a good example is, let's say that the family knows that a third party told somebody else that they saw well, they're not the defendant yet, but let's call them a defendant. The perpetrator, sorry, that'd be the right term. The perpetrator, or who they believe to be the perpetrator, roaming around the neighborhood before the homicide occurred, right? Now, that could be admissible, it could not be admissible. It depends. Like I'm not an attorney, so I can't make that decision. But if it's not admissible, right, for whatever reason, and the prosecutor can explain thoroughly why it wouldn't be admissible, and that's where that meeting would be set up too. Um, if it's not admissible, it doesn't, not that it doesn't matter that it sounds like the perpetrator was around the victim before the homicide happened. Of course, that matters, right? And it matters immensely to families, and they also probably, if this is somebody that they knew had threatened their loved one before, or there was like a rocky relationship or something before, even more so, the family has kind of background information too that they're going off of this information that they're given. So it does matter, and it is important, but it might not be admissible to the courts. So it won't go to the courts, so they can't use it. And if they can't use it, if that's where all the case lies on that, they're not going to be able to move forward with charges for who they believe the perpetrator is. And those conversations are incredibly hard to have with clients. One, because like I said, they have information prior about their loved one, whatever, background information they've had, they know their loved one, right? They know the relationships they've had. They know the patterns their loved ones had, if this is out of the norm for them, all these things, they have that information. And then they're hearing additional information that kind of solidifies what they feel or think. And, that's important. It's not that it's not important, but if it can't go to the court, then it doesn't matter to the court, I guess is the best way to explain it. And it's not a fun conversation to have. I also don't have these conversations one-on-one with clients. I always have those with the prosecutor or the DA's office present, because they're going to be much more equipped to answer detailed questions about why these things are happening than like I can be, because like I said, I'm not an attorney. So if you find yourself in that situation, I 100% recommend that you make a meeting with the DA's office so these questions can be answered, the concerns can be brought up by the family, and they can hear from an attorney themselves why this is not moving forward. So witnesses unavailable or unwilling. Sometimes a whole case can rely primarily on a witness. Witnesses sometimes are scared, especially if we're talking about a homicide case. They have a very clear understanding of what can happen to somebody by potentially a perpetrator, their witness, right? They're scared. And so they may leave state, they may go into hiding. They may, it's very rare that I've seen it. I have seen it in two cases where they would prefer to go to jail rather than be a witness. And when I see something like that, I mean, and it's just my personal feeling and being in this position for so long and work doing this work, it makes me think, wow, this person is terrified of this perpetrator. And most likely rightfully so, because if you're going to choose to do jail time over taking the stand, um, because they're afraid of not just maybe the perpetrator, but also the perpetrator's, connections around them that could also still do them harm, even if the perpetrator's in jail. Um, that's very valid for a witness to feel like that. Um, it is not great though for your client, who is either most likely a surviving family member at that point, because if they if the witness is where the cut case heavily relies on and we can't get them there to take the stand, or not we, but the courts can't, then the case doesn't move forward. If they can't find them, if they've left state, the case doesn't move forward. Um, so evidence does not meet the burden of proof. Um, some things, you can have a ton of evidence and it's just almost where it needs to be to get those charges, but not quite. And that's where that, being able to do without a reasonable doubt for the charges, if it doesn't meet it, it's not moving forward. And so the evidence could be admissible, right? They could have evidence they can give to the court. It just doesn't quite get to that threshold. And then, of course, they won't move forward with the charges for the perpetrator. Sorry, they're not the defendant at that point. Self-defense or legal defenses could be applying. And this is also a very hard question or hard situation you might find yourself in. If there is what we will often call, especially in domestic violence situations, mutual combat. So it is very normal for, and we'll look at a domestic violence case where a homicide is the end result. It's very normal in a domestic violence relationship that there is what we call mutual combat, where the abuser is, initiating attacks on the victim, and then the victim fights back. And sometimes the victim is going to injure the abuser. A lot of times they're going to. And that's like that mutual combat. They're going at it together, right? Doesn't mean that the victim isn't a victim, right? They're still a victim. It just means that they fought back. And sometimes, depending on the situation, if when they fight back, it ends up in the death of the abuser, it could be seen as or sorry, I'm saying that wrong. If it ends up in the death of the victim, so an abuser is attacking a victim, the victim fights back to save themselves, the abuser ends up continuing to harm the victim, results in their death. It can at times be seen as self-defense. There's a variety of reasons why that could happen. Some of it, well, I guess the most common one that I've seen is that the victim maybe brings out a weapon, let's say a knife or a gun. The abuser is attacking them with their hands, right? Even though the abuser, let's say, has the upper hand because they're bigger, they're stronger, and everything. The way that law enforcement can look at that and the prosecutor's office can look at that is that the victim didn't have to um, or go that far with the knife, right? And because they brought out the knife, well, now that escalates to the abuser having to escalate, you know, their abuse, right? Which ends up being in the result of the death of the victim. And now it's looked at like, well, she or he had the knife, she or he didn't. Who do we, you know, I don't like to say it like this because I don't feel that this is, it's my personal feeling. I don't like seeing these situations. But looking at it in a neutral sense, you're saying, oh, well, maybe it didn't need to escalate to that point, and that person then had to defend themselves. So when those situations happen, not fun conversations to have. Always have them with the prosecutor's office there, please, because it is, especially if there was a history of domestic violence on the victim prior, that is now deceased. The family is going to feel incredibly upset by hearing that, right? Because they're going to know all the abuse that their loved one went through before it ended in their death. And then to hear then that that person is not going to be held accountable because they were defending themselves is going to just not go over well. It has never gone over well in a situation that I've sat in. And I, one, am not someone who should be in a position to explain that. That's not, where our jobs lie as someone who's helping victims. It is really 100% on the prosecutor to have that thorough conversation. It is good, I say, to be there for the family in those meetings as an emotional support. But those are hard ones. Those are hard ones for a lot of reasons. Um, Investigations remain incomplete. So, you'll have what we'll call, like, I'm sure you guys have heard, cold cases, right? They're still open cases. It's ongoing, but they don't have, a lot of times it's based on evidence. They don't have enough evidence to move forward with any charges on somebody. They might not have enough evidence to even know who committed the crime. So it's not a complete investigation. It's still open or cold, like cold. Usually cold cases are when they're open for a really long time, but we'll just say it's an open investigation. It remains an open case, which is also hard for families, right? Because they want some closure. Cold cases can remain cold for decades. But I like to say, as technology has gotten better in the last 50 years or more, new things are coming up all the time on how they can look at evidence and test evidence. So if a case is cold today, it might not be cold in 5 years. So, I always tell families, I don't want you to lose hope. And I know it's really frustrating. I always recommend, doing a yearly check-in because you just don't know. There could be either new evidence that comes up that is, they don't currently have, and it just breaks open the case, or there can be new technology and they can test old evidence and that breaks open the case. So an open investigation or a cold case is not meaning like it's done, right? It's still there. And I want people to always have hope in that. Um, and knowing, it might take a while before this might be solved. It might not be solved either, but there's some hope. So additional forensic testing is needed. There could be things that this is a hard one also to sit with families because then they have a million questions when this happens. If during the initial investigation, like not everything was collected, which happens a lot, then that evidence is like could be lost, can never be salvageable again. A lot of things could happen with physical evidence on a person, especially if that individual ends up being like cremated, or the evidence that's needed to move forward with charges like is something that deteriorates quickly on a body. Even like being able to bring the body to test again might not produce the evidence that's needed. So sometimes you're going to have that issue where it's like there needs to be more forensic testing, and they can't do it for a variety of reasons. Or on the other side, they can collect, right, and they don't have the ability to test something right now in this current time, with our technology now, but maybe in 5 or 10 years they can. So there's, I would say that happens probably quite often. A lot of times more so in suspicious death cases is where we see this, because when a death is not initially looked at as a homicide, it's not treated as a homicide by law enforcement. Therefore, the evidence is not collected as it should be for homicide. And so they're losing a lot of evidence, and the forensic testing that could be done is not, they're not able to do that. Um, and then the suspect cannot currently be prosecuted. So as I wrote this and I was looking back at my slide, I was like, I should have written that a little bit better. So I would explain this one a little more. Um, why I put that in there is that I've had a good amount of cases, enough to where it stuck out, right, where I want to mention it. Um, is that a suspect is commits a crime here in Alaska, right? They commit it, let's say Anchorage. Shortly after, they leave state, and then they end up leaving the country. So they end up going to, let's say, Mexico. Just throw that out there because it's close to us. Maybe Canada. Well, probably not so much Canada because they're better at extraditing, but let's say Mexico, or somewhere where it's just going to be harder to extradite somebody, right? To bring them back up here. And also at that point, if there's not 100% like enough evidence where they know that they were going to have charges against this person, it's just that they're a suspect, like a high potential suspect, they might not work as hard to get that person back. So for that situation, like I've had families where they feel they know who did the crime, right? They know that person left the country. The prosecutor's office knows that person left the country. They cannot find that person. He or she cannot be prosecuted. They're not able to be. Another example of that also, and this isn't saying that it's not a decline of charges, but something that might be considered for charges is somebody's like mental health. So if that person has been charged with violent crimes in the past, and they are incompetent for all these previous charges, sometimes you'll also see where it's not that they can't be prosecuted, but it's less likely because they know that that person's not going to, he or she is incompetent, right? And in Alaska, we have a really big problem with that. It's getting a little bit better in terms of like what that outcome looks like. But if somebody is deemed incompetent, they cannot, whatever the charge, doesn't matter what the charge is, they are not going to be held liable for those charges because they're incompetent. We are getting better with being able to put people in institutions, because we're expanding a little bit our criminal institution facilities. But up until maybe 5 years ago, yeah, I would say 5 years ago, one of the very few places people could go for a case like that, a situation like that, would be API, and we only had 4 beds available at API to hold incompetent people who were deemed incompetent for like a very severe violent crime. So 4 beds with a lot of people who have, the competency issues. It's not enough space. And they can only hold somebody in jail a certain amount of time before they have to let them go by law. So what would generally end up happening is that the person would stay in jail for a certain amount of time, waiting on this bed to be open, or a bed to be open in API. Bed would not become open most likely, and then they're let out of the jail. And then that they're a clean slate. So no charges were, they're not charges were put against them, but they were, found incompetent. So there's no sentence, I guess is what I should say. Sorry. There's no sentence. They didn't do sentence. That time in the jail that they're waiting is not a sentence. It's the time that they're waiting to try to get into the API bed. And like I said, generally speaking, they're not going to. Now, we have expanded some beds in Alaska, and so we are seeing a little bit of hope in that. And I hope to see that we expand even more beds throughout the state because we need them here. So, a case reflection. 8 months ago, James, a 29-year-old Indigenous man, was killed during an assault outside a local business. Law enforcement responded quickly, interviewed several witnesses, collected surveillance video, and identified a suspect. The suspect was interviewed but was not arrested. Since the investigation began, James' family has remained actively involved. They have spoken with detectives several times, attended community meetings, and stayed in contact with the victim advocate. Although detectives have explained that the investigation is ongoing, the family has received very few updates over the past 3 months. Recently, the lead detective informed the family that the investigation had been submitted to the district attorney's office for review. Several weeks have passed, but no criminal charges have been filed. James's mother believes the prosecutor is choosing not to move forward with the case. His sister has begun posting on social media asking why the DA refuses to prosecute, and several community members are encouraging the family to hold a press conference. The family has now been invited to meet with the prosecutor and the victim witness paralegal. They are hopeful they will finally receive answers, but they are also frustrated, grieving, and worried that their loved one's case is being ignored. As their advocate, you are preparing the family for this meeting. So some of the challenges that from this case that we're seeing is, the family is receiving few updates about the case. Sounds like they're in contact with the detective. They know who the lead detective is. They're just not being informed on a regular basis. Maybe they would like a weekly or every 2-week update, and they're not getting that. No charges. No charges discussion has been made after the case was submitted to the DA. No charging discussion. So, they know that the case has gone over to the DA's office. They have not heard what's coming of that, basically what's going on next. Why have we not been updated? And that's not uncommon either. That actually is really common. So they're just wanting to know, I think as any of us would want to know what's happening with that. And then social media and community members are increasing the family's frustration. That's also, I always add social media in there because social media is a big thing. You put something on social media, everyone's got an opinion, right? Everyone has their own opinion. And for families, that could be hard. And it actually can become a big conflict within families because everyone grieves differently, everyone processes things differently. And if you're having outside opinions coming in, it can, sway people this way or that way, and it could just cause a lot of friction within the family. The family is preparing for an emotional first meeting with the prosecutor. So they know they're going to have this meeting. They're obviously upset about lack of communication. They're still grieving and processing. They don't know what's going to happen. So the key questions we have are, what key concerns could the family raise during the meeting? What questions could the family ask the district attorney? What advocacy opportunities exist? And how can trauma-informed communication support the family during this meeting? So I'll give everyone a minute if you want to jump in before I go. The next slide will have some answers, but if you have any ideas, I'll let you go.
Yeah, I feel like advocacy just around like in that meeting, being able to advocate for like a more consistent update or timeline. I feel like their questions are going to be like, what's going on? Are we prosecuting? Other things like that.
Yeah, definitely. getting some solid answers for them, or at least hearing it from the prosecutor themselves. All right, I'm going to go to the next slide. And then we still have a question section even after this, if you have any questions after. So what key concerns could the family raise during the meeting? Lack of communication and limited case updates. So just like you said, Liz, hey, why are we not, getting updates regularly? Can we get some information here, and can we keep that flowing? Will you keep messaging, or sorry, not messaging, emailing us regularly? The length of time it is taken to make a charging decision. A lot of times that'll be the thing, is the family will be thinking, well, if it went over to you guys already, how come this person isn't in jail? That's, generally what I'll hear a lot of times as well. Why are they in jail? It already went over to the prosecutor's office. Why are they still walking around town? And that's a question that definitely is for the prosecutor to answer. And then questions about whether additional evidence or testing is still pending. So, I always would add that in there for a family to think about, because sometimes they might not consider that. I just know that is, from doing this for so long, is like maybe the holdup is evidence. A lot of times it is evidence if there's still taking a while to charge somebody and, with the crime. It's usually evidence based. So is it about evidence? Is there, are we waiting for a test to come through? What is holding this up, right? A lot of times it will be evidence. How they will be kept informed moving forward. It's also, like you said, Liz, like, can you, let me know what kind of updates you're going to give me on a regular basis. A lot of the times, also in these meetings, because the victim witness paralegal will be there, I would tell the family, hey, maybe we could direct that question to the paralegal and say, since I have your email and you have our email, can you update us? I would say like every 2 weeks is probably the most reasonable you'll get. And just putting that out there and saying, do you mind, even if there's no new information, just sending an email saying, hey, we're still in, waiting for evidence, or we're still, whatever they're waiting for. What to expect if charges are filed or if the case is declined. So I also like to get that in that meeting as well, so that if charges are filed, hopefully we're not having to set another meeting like right away. So we're kind of like preempting some stuff. And also, if the case is declined, so if we're still waiting on evidence, that evidence doesn't come through, or it's not admissible for some reason, what can this family expect? How will that information be communicated to them? If a case is declined, I always prefer to have that conversation happen with the family in a meeting, not through an email. So that is something that on the side I would talk with the prosecutor and paralegal about, is if this doesn't move forward, can you please set a meeting so that information can be given to them? Because that's not a fun thing to read in an email as a surviving family member. And then to also have to there sit and wait for a meeting to become available, it's not it's not a victim-centered way to handle that. So that's kind of why putting that out there preemptively too, because a lot of prosecutors and witness paralegals are not victim-centered in their communication or in how they work. Some are really great. Some not so much. And not because they don't care about these families, but it's just, we all have different things that we're good at, right? And I always like to add, like, for anyone in the legal field, they're really analytical thinkers. They're very, straightforward, and this is just my experience. My husband's also paralegal. Like it's just how they are. And they don't necessarily like that doesn't always transition well to victim-centered communication, because that the way that they're communicating within their workspaces is way different from like how I'm communicating in my workspaces with my clients and with my colleagues. So it is very different, and um, it might not be at the top of their mind to think, oh, we should set a meeting to discuss that this case isn't moving forward with this family. They might think, oh, I'll just send this email. They wanted updates. That would be the update. And then they could email me back with questions. That would be very normal for a prosecutor to think. And like I said, it's not because they're these evil people that don't care about others. Like, no, it's just that's how they work, how they operate, generally speaking, right? And so that's also kind of where we could come in and say, hey, just to let you know, this might be a better way to do it. And like I said, I have not, very rarely have I ever had any pushback on some of the things that I'm saying with that I bring it out to like talk with prosecutors about. I think sometimes it opens their eyes a little bit in a way to be like, oh, actually, I didn't think of that, and I can see how that could be really traumatic for a family, right? And like I said, generally speaking, I haven't met a prosecutor that I thought was this, person that didn't care about others. So it's just kind of letting them be aware, right? And preempting some of those things for your families and your victims. And then how the family can continue to participate and exercise their victims' rights. So, one of the things is if, they're in this meeting, they should feel comfortable to ask, like, what can we do? If we're in this waiting period, right, where we don't know what's going to happen, well, what can we continue to do? Like I said, they can sign up for notifications of if the perpetrator is arrested. There's links to get that done. They can be able to kind of follow along at a very minimal way, and the prosecutor can explain that pretty well to them. And that's also kind of preempting what if there is charges that are filed, that conversation as well as, okay, well, if there are charges filed, can we come to the bail hearing, which they can, but those are things like that they can ask and know that they're allowed to participate in. Can they give a statement at bail hearings, which they can. Those are things that they can participate in and kind of be preemptive, like about if it happens this way where there are charges filed, or if, that person is arrested. And then they also should be like, this is where when I talk about like if there's a bail hearing and they can give a statement, that's part of their right as surviving family members or victims, is at bail hearings they get to participate and speak to the court about concerns with the bail. So that's would be exercising their victims' rights. And that's usually what you're going to see in the very beginning of a case when it comes to like how they can participate and what we can preemptively get them prepared for. And then what questions could the family ask the district attorney? So what stage is the case currently in? They know it's gone over to the DA's office. What are we waiting for? Kind of what's going on? They should, and the prosecutor should be able to answer that. Has a charging decision been made? Which is a good question, because a lot of times you're thinking, well, if it's over at the DA's office, have you guys, made a decision and you're waiting for, something? I don't know. Those are things that definitely you're going to the family's going to be able to get clarification on what's happening while they're in this like waiting period, if we're asking these questions. So is there additional evidence still needed? are there legal reasons that prevent charges from being filed right now? So yeah, if they're saying, oh, we have everything, we can't file, we're still waiting. Well, what's the holdup? Kind of, is there, can you give me the legal reason why we're not moving forward? And they should be able to give that to the family. How will they receive future updates, emails, phone calls, how they prefer it, things like that. Who should we contact if we have additional questions, which will generally be the victim witness paralegal. But it's still good for them, like I said, just because like I know the answers and like eventually you all might know the answers. We still want to have them be able to ask the questions, right? So they feel like they're got some power in the situation that they're going through. So that's a great question is, who can I contact? And they will most likely say, contact the paralegal and he or she will get to me about your questions. And then if charges are not filed, will someone explain why? And that's also where we can preemptively say, hey, if things aren't filed, or I like to say it this way, if charges are filed or they are not filed, because I don't want a family to think that a meeting is automatically bad. I would say, hey, will we be able to like just schedule a meeting shortly after that decision is made? Can you send me an email letting me know that a decision has been made and we're going to have a meeting about that? So kind of, like I said, getting ahead of it a little bit. That way, when the time comes, they're getting it hopefully they're getting the information in a victim-centered way. And they're also going to be able to have the chance to ask questions to the prosecutor directly in that moment that they're getting that information, especially if it's information that the charges are not going to be moving forward. I want them to have that opportunity as soon as possible to have those questions answered. And then what advocacy opportunities exist? So meet with the family before the appointment to organize their questions, help prioritize the most important concerns. Um, I always like to have families like write down in general all their questions, and then we kind of group them in sections that flow. Because a lot of times the way that we're thinking, especially during grief, it's not flowing, in a way that always makes sense. So I always say, write down everything you're thinking, and then later we can help group those things into sections to ask to the prosecutor. And then explain the prosecutor's role and legal responsibilities, letting them know that they are representing the state and they have to be able to prove without a reasonable doubt that this person did the crime in order to move forward with charges. And then they represent the state if that's the case. And then prepare the family for information the prosecutor may not be able to disclose. So that's where those investigative limitations come in, just letting them know there might be things you're not going to get answers to, and it's not because they don't want to give them to you or because they don't have the answers to your questions. It could purely be that they're protecting the case. Just giving them that heads up so that they don't go in surprised or upset if they're told that their information can't be given to them. Like I said, I like to prepare people, especially for things that are going to be upsetting. I can't change that. It will be upsetting, but I can at least, give you a little hand so it's not as surprising. And then attend the meeting to provide emotional support. I always say if I could attend it, a lot of people will attend like in person, or you could be there like on the phone, because the prosecutor's office will usually they could have you on the intercom system that they have, so you're part of the conversation. I really prefer to go in person. I know that there will be times when that won't be possible for, different reasons, but if you can attend the meeting in person, it really is a great way to be able to provide that emotional support immediately after, because they will need that after. If you can't, if there's things that come up and you're not able to, it's still obviously attending on the phone is still good, and then you could have a phone call after the meeting. and then take notes during the meeting so the family can review the information later. So I take my own notes when I'm sitting in any of these meetings. They look crazy. They're like 10 pages long. They make no sense to anybody else. But I take all the notes that I have. I then clean up all my stuff. I organize it, and then I always send it over to the client, usually within 1 to 2 days after. So they have their own notes that they most likely are taking during the meeting. They have then also my notes so they can be able to review everything and see if they missed anything or, just to have all that information available to them. And then follow up with the victim witness paralegal after the meeting if additional clarification is needed. So if there's questions after, like I said, that's where you'll probably go to is the victim witness paralegal to see if maybe they can answer that or if they need to get that information directly from the prosecutor. And then connect the family with counseling, peer support, or cultural supports if the meeting is emotionally difficult. So also depending on the meeting, I would maybe even preempt that. So if they're already seeing a counselor, a lot of times I'll say, maybe you want to make a meeting right after, or a counseling session right after this meeting, like the next day. If they are not seeing a counselor, then I might, make that recommendation, especially after a meeting that's going to be really difficult is, hey, have you considered, you know, talking with a counselor? Because this is going to be some heavy stuff that you're going to be receiving. I never push anybody, obviously, to seek counseling, peer support, or cultural supports. I just like to heavily recommend it and then hope that they take it. It's always up to them, of course, but it is very helpful for these families to have one of these supports or multiple of them, even if they don't feel like they need it or want it at the moment. I think knowing that it's out there is helpful to them so that when the time comes, they can reach out to you and get it and know that you already brought it up to them. Because I don't think, I mean, and this is just my opinion, but I don't think there's really been a time where I've seen a family that I would have said, oh, they definitely don't need help after this, right? I feel like anybody would. It's hard stuff, it's hard things to process. And that's where having that extra, you know, knowledge therapeutically, which is not what I have, that's not what I do, is helpful. I want to get my clients the right mental health support that they need. And my emotional support is helpful, but it's not the same as that. And so um, just letting them know it's there, letting them know if and when they want it, you got the information for them. And then how can trauma-informed communication support the family during this meeting? So we always want to acknowledge the family's grief, their frustration, and the uncertainty. And like I said, the prosecutor might not be able to do that. And that's a lot of times where we will come in and maybe be able to speak up a little bit for some of our clients if they're not able to in that moment. But they're going through a lot. It's hard, and they're going through a really difficult thing of sitting in this weird setting with these attorneys that are speaking the language that they're not used to, on top of everything else that they're feeling. So all the feelings that they have about these things are valid. Being frustrated, being mad, valid. Allow family members time to ask questions without rushing them. So, definitely I always let family members have the floor when we go into these meetings. I will speak up if I can read that maybe my client might need my help a little bit. But I do take a step back a little bit to kind of allow them to lead the way. And then sometimes at the end of the meeting, if I'm like, oh, I think it would benefit them to know this information, then I would probably bring it up in the meeting. But I don't ever want them to feel rushed. I don't ever want them to feel like they have to get all their questions out really quick because, oh, we only have, 20 minutes or something. And which might be the case that there's only a 20-minute scheduled meeting, but I don't want them to feel that. So there are ways that we can definitely try to calm that and be like, listen, go at your own pace. If we go over time, that's okay. We might need to set up another meeting. That's also okay. But, take your time, make sure that you feel comfortable with what you're asking, and we'll move, we'll make plans accordingly after if everything doesn't get answered in that meeting. And then using plain language instead of legal jargon, that's a big one. I have to catch myself sometimes, like I talk like a normal person. That's why I talk pretty normal. But one of the things I notice I do a lot is I speak in acronyms because it's easier and it's what I'm used to communicating with, like with colleagues. And so even for myself, like I have to remember when I'm talking with families, don't say OVR. They don't know what OVR is. Who knows what OVR is? Say the full name. So even for us sometimes even if we are people who speak regularly and have, that is our normal way of speaking, we probably still have some things to always work on. Everyone, like I said, we always can work on things. Um, be honest about what is known and what remains unknown. You know, I always am very upfront with my clients about what we can do and what we can't do, in terms of what I offer. If I don't know something, that is completely fine. I will try to find the answer. And also, we might not find the answer. So, just being very open to having that conversation with clients so that they know it's okay to not know something, and it's okay to you might not get the answer right away. But we'll keep trying. So we never want to make promises about criminal charges or timelines. And that's on us, right? Is like before a meeting, I never tell a client that this is going to, for sure he's going to get charged or she's going to get charged. I would never say that. I don't know. I give a general idea of what timelines we're looking at. I say, for homicide cases, it can take months, which is rare, or it could take years. Um, so very vague, letting them know, these are generalities here. And then validate emotions without criticizing the legal process. And that is also can be hard because you yourself might be critical of the process and have your own personal feelings. But we don't want to do that for them, right? Because that is kind of also a boundary crossing in terms of like, I'm a professional and I need to handle myself as a professional. And I could have my own personal feelings about something, but that would be very unprofessional for me to say those feelings. And also it muddies the water a little bit if your client sees you more like a friend, than as their advocate or the professional helping them through this process. Um, I validate emotions all the time because I feel like everyone's emotions are valid, even, no matter what they are. I think emotions are valid. Um, but yeah, especially for legal processes, if I feel like this person should be charged, it's my personal feeling. I think that the prosecution is wrong for not moving forward, or the reason that they gave, I don't agree with, which has happened hundreds of times. That's my feeling, right? And I will hold on to that, but I will not say that to my client. It just is a boundary that I don't cross, and I recommend people don't cross. We have to maintain that professionalism with them so that they view us as impartial professionals. And that's what ends up happening is if we don't do that, then we're not impartial, right? We are, and obviously we're on their side, but it's just in a different way. And so, I will validate everything that they're feeling and say, I totally understand why you feel like this. And I can imagine that it's really hard to hear that they're not going to move forward with charges. And, please take the rest of the day and maybe next few days to be easy on yourself and maybe take some time off if you can to process some of those things. And, that's kind of what I would say after a meeting. I wouldn't say, yeah, I think it's wrong. They're not moving forward with charges. They're idiots. Like I could think that in my brain, not going to come out of my mouth, not in front of a client. Um, Maybe when I get back to the office and I'm talking to a colleague and I'm mad about it. But yeah, just be very careful with that. It's hard because we are humans too, and we have feelings too and opinions. And we also become really close with some of our clients because we're working with them a lot. So it's very easy to that boundary to get blurred there. But I would say work hard not to blur it. And then reinforce that asking questions and seeking clarification is appropriate. There are no dumb questions. I know we have probably have all heard that, and I do stand firm with that belief that there are there's nothing, no such thing as a stupid question. Every question is okay to be asked. We all have different backgrounds and different things that we're knowledgeable about. And so there should be, no reason that somebody should feel that their question, shouldn't be asked because, oh, that's dumb. Of course, I shouldn't ask that. No, absolutely. Ask your question. If you don't understand what is being explained, ask, can you explain that in a different way to me? Um, I want my clients to feel comfortable with speaking up for themselves and also receiving that information in a way that they understand. Um, and so, yeah, if there's ever a time that you feel like a client might hesitate to ask because they don't, feel like, oh, I don't want to ask that. It's probably is like, it's a dumb question or something, I absolutely say, no, that's a great question. You should ask it. You should ask it. I think, or I didn't understand what that meant. But yeah, I'm sure it's fine. No, you should ask. Let's ask for them to clarify that. Let's get it explained differently for you. I want you to know the answer. So just kind of, that's just tidbits on how I do it. Because I want clients to feel good, good about being part of this process as much as they can be. I mean, it's not a good feeling to be part of the process, but we can help them to at least feel comfortable in some ways. So reflection questions, which are just some things to think about on your own, would be how would you explain the prosecutor's role to a family in plain language? So I know I explained a lot of stuff, and I know I generally use plain language. But if there was even a way, because your communities, right? What kind of the lingo is where you're at. So there might even be a different way that you would explain what I've explained. And I highly recommend thinking about that because every community is different and every person is different and how they receive information is different. So thinking about how would I explain that so that my client would get what I'm saying easily. And then what expectations should families have when communicating with the DA's office? I always say writing that down. So also as you're learning yourself, because that way you have that information too. And that way you can kind of pass it over to them when the time comes. And then how can advocates prepare families for difficult conversations with prosecutors? Like I said, preempting some of the things that you can, and also thinking about, recommending or referring mental health services after, seeing if they're willing to take that, because that is really key to helping them after these difficult meetings. And then what trauma-informed practices can improve communication throughout the prosecution process. So that, also kind of thinking on your own. I know I spoke a lot about it, but I think especially when you are already working with a vulnerable community, which it seems like most of you are, you are already most likely using trauma-informed practices anyways. So maybe thinking of how you're using those practices within your own profession currently and applying it to talking about the criminal justice system. How would you explain it? Because I also want people, if you're having these conversations with clients, I want you to also feel comfortable with how you're explaining it. And how I explain it might not be how you would explain it. So any questions before we got one more module and then all right, I will take that as no questions. And remember, you can always email me too after or at any time if something pops up. So we did prosecution communication. Now we're talking about law enforcement communication. Very similar, also very different. So basically, we're going to go over how we communicate with investigators. So we have detectives, investigators, law enforcement. They're basically all the same thing in terms of who you're going to be communicating with. Most of the time, it's going to be a lead detective would be who, in a homicide case for MMIP, that's who you would be talking with. Or if there's a missing person case, there's usually a lead detective that you will become probably really familiar with. So we will go over explaining why communication may be limited during an active investigation, helping families communicate effectively with investigators, recognizing when communication has broken down, and then identify appropriate advocacy strategies, and then use documentation and trauma-informed communication to strengthen our advocacy. So we're going to go over like how we did with the prosecutor's role. What's the law enforcement's role, right? And they are two different roles for sure. Some of these things overlap a little bit. A lot of it doesn't though. And they are two very distinct departments that work together. And sometimes, especially for victims and families, that could be really confusing because they can see it kind of as like one whole department in a sense. They're like, oh, the police and the attorneys, they're together. And so that's where like having a really clear understanding about their different roles and being able to explain that to clients is very helpful so that they understand that actually these are different roles for sure. And that the process is different for each one and how we communicate with them also can look different. So what do investigators do? They collect and preserve evidence, especially if we're talking about a homicide situation. They have a whole particular process for homicide evidence collection. And it's pretty much the same no matter what law enforcement is looking into the crime. It's pretty standard. The state standards for this are almost all the same. So they also interview victims, witnesses, and suspects. They coordinate any forensic testing. So coordinating, that means that they are the ones that are collecting, let's say, fingerprints, fluids, substances, whatever. They're collecting all of that because that's what's all eventually going to be tested. And then they're sending that out. So that evidence also would look different than what the medical examiner is collecting as well. Because medical examiner is collecting, like, let's say, fluids on the body, and law enforcement is collecting, let's say, fluids on the ground in a house. But they're both going to end up being tested eventually. Well, they should both end up being tested. And then they follow investigative leads. So they're the ones that are, if they think somebody is a suspect or multiple people are suspects, they're going to be following those leads, trying to see if they can make, enough evidence to give over so that a case can be brought. They work with prosecutors and the medical examiner. So these three departments all work pretty closely. I would say the law enforcement and the prosecutors work the closest together. but they still do have a lot of interaction with the medical examiner. And law enforcement, I would say, probably has more engagement with the medical examiner than the prosecutors do, because they are the ones that are like making sure the body is getting over to the medical examiner's office. They're the ones collecting evidence around the body, and they're the ones that are initially talking with the medical examiner when individuals being transferred over to their care in the medical examiner's office. And then continue gathering evidence until the investigation is complete. So even like I said, if you have an open case that's been open for decades, they are still supposed to gather any evidence that might come, come before them. Even, an open case, a cold case is still, there's still opportunities for evidence to come up and to be collected. And so they should be following up on any leads where there may be evidence. So why communication may be limited? And this is really key to explain, especially to families when there are some issues with hearing back from the lead detective. So if an investigation is still active, there is a lot of things that law enforcement will not divulge to the family or the victim. An active investigation is like a vault. Is so you said it. It's they really lock it down for a lot of reasons, and mainly because they're collecting evidence, right? To hopefully that there's a criminal case that will come out of it once they pass it over to the prosecution. But if anything gets messed up in that investigation because the information got out, right? Then they may not be able to collect the evidence that they need, do the interviews that they need, or that may end up being the evidence that they collect or interviews that they have may become inadmissible, and then prosecution can't use it. So there's a big reason why an active and open investigation is locked like a vault. And it is very frustrating for families and victims when this happens because they want answers and they're not going to be able to get them. Some stuff they'll be able to answer, but a lot of things the law enforcement is not going to answer for them. So I always tell families, during this point, be as patient as they can, and we can ask for updates on what can be updated about, but also, they are doing their job by keeping this information locked down like a vault. They are doing what they're supposed to do. If they were just letting all this stuff out, that compromises the case, right? So it doesn't always make people feel better, but it is, like I said, it's a reality. And so I hope to soften that reality a little bit by saying, hey, if they were letting all this information out, you guys might not get a good case later. So, let's look at it like, okay, they're doing what they're supposed to do. And let's see what happens, once it gets over to the prosecution's office, you might get more information. Also, though, still, once it's there, it's also locked down as well. So it's frustrating no matter what for families. They want answers, they're probably not going to get them right away. And then, so there could also still be testing that is pending. Like I said, we've gotten better about our testing abilities here in the state of Alaska, but we're still not, up to par as some of the other lower 48 states. We still have to send things out, and sending things out takes time. Witness interviews are ongoing. Witnesses can be people that want to help, and also there can be ones that don't want to help, right? And it might take a while to get those interviews completed. So, if they're still waiting on witness and evidence and things like this, the communication is not going to probably be on the top for law enforcement, is not going to be on the top of their mind in terms of how they communicate with the family. But that's also kind of where we come in. So Information could compromise the investigation. That goes up to like the investigation is still active. If you give something out, it could compromise things. That's something we don't want to happen. And then confidentiality laws restrict disclosure. So there are certain things that a family may never find out due to confidentiality laws, and there's not much that can be done about that. It's a law. Um, a good example is we'll have families sometimes who, let's say, their loved one was murdered in a crowded space where there was lots of people, right? And there was maybe 10 witnesses. The family may want to know who all the witnesses were. Now, some of those witnesses may, be part of the charges later on in terms of being witnesses in the case, and some may not, right? They may have just been in their car when, let's say it's a shooting, right? When the shooting happened in front of the building, but they didn't really see anything. So it's not necessarily that they're going to be useful to the case of the criminal case later. If they're not, and the prosecution is like, yeah, we're not really going to use them, they don't have any information that's useful to be used, then they, they have the right to have confidentiality if they're not part of that case like that. And that can be frustrating for families because they may want to know who, like everybody who saw their loved one, sorry, everyone who saw their loved one, who was there, who saw what, and things like that. But they're not going to be able to get that information. Um, and it's frustrating, but like I said, it's the way that laws are. And we just have to kind of soften the blow as much as we can when we give that to them. And also, it is helpful to have law enforcement, the lead detective there when you're having this conversation so that they can also give that talk to the family and explain it better. So setting realistic expectations. Families may receive major investigative updates. So they're most likely going to be contacted like when somebody's arrested. They will be contacted, I mean, honestly, probably just when they're arrested by law enforcement. Really, law enforcement is not always great at communicating. And so it's not really something that they always have to do, right? To be like in continued communication with surviving family members. So it will probably be like a major situation that happens is when the lead detective's going to make that call to the family. Or if they have a new suspect, maybe that they're thinking, hey, this is going to probably lead to an arrest. They may give an update to say, we have, new information and they're not going to say we have a new suspect or, give all those details, but they may at that point be on their own communicating to the family that we have new information that we're following up on, just letting you know. And then a notification of significant case developments. So, if, like I said, it's going over to the prosecution's office and it's going from their hands to the prosecutor, most likely that's when they're going to be contacting the family to give them that information. Information that can be legally shared. So, like I said, there are things that cannot be shared. So the only information they're going to get is stuff that can be legally shared and that isn't going to compromise the investigation, which also, it can be frustrating for families. And then opportunities to ask questions. So usually when law enforcement calls the family to let them know something, they will take questions in that moment. I still like to set up separate meetings though, because you don't, that phone call where they're getting that information is not necessarily always at the best moment for families. So they're not going to always like think of their questions right away. But they usually will at least, give them that opportunity. And then families may not receive daily updates. That's a big one. That is a lot of times, especially in a homicide case, families really expect to be, uh, told what's happening like daily. That is most likely not going to happen. Um, they're not going to receive, the confidential investigative details. They're going to probably be told no on some information, quite a bit actually. They will not get copies of any evidence, especially if it's going to end up being a criminal case, because that then becomes even more so locked down. Now, if the case ends up being where they're like, okay, we're not going to go forward with any criminal charges, you can get copies of reports and things like that. But that comes later after they decide that the prosecutor decides not to move forward with criminal charges. But in the moment of an investigation, the family and victim will not get any evidence information. They won't get copies of anything. If it goes to a criminal case, they will not get copies of anything. It's all locked down. And then information that could jeopardize the case. So, yeah, they got to keep a lot of stuff under lock and key. And then they might not get immediate answers to every question either. So they could have questions, and it could be that they just might not be able to get the information because it's not something that can be shared yet. Or it could be that the lead investigator has to see if that's something that they can answer. There can be a variety of reasons, but I like to set expectations with families that, you might not get an answer to your question, or you might not get it answered right away. And so it doesn't mean that the question isn't a valid question. It just means that not to have the thought like, oh, I'm going to get this answered, soon. Because it will be very disappointing when that doesn't happen. So building productive communication. And this is really key, right? Because we want our meetings with families and law enforcement to be productive, because we want, one, for the families to feel good when they leave those meetings. And two, we want law enforcement to want to continue to talk with the families, which shouldn't be our responsibility to try to ensure. But I would be lying to you if I said that if we don't try to make it as comfortable for everyone as possible, that law enforcement might limit the times that they're willing to meet with a family. So that's why it's really important to try to mitigate some situations before they get bad. Because if a lead detective decides they don't really want to communicate with the family very much, they can make that decision. Because at that point, if there's no criminal charges, they're not obligated to. So we want to encourage families to identify one or two primary family contacts. So I usually ask next of kin, and then maybe somebody who is close to the person that is deceased, or close to the next of kin to be the secondary. Because sometimes your next of kin, obviously could be a mother or a spouse, and they're not always going to be in the best mental space to handle some of the information they're going to receive. And that's why it would be good to have that backup contact of somebody who obviously still loved and cared about the person that's deceased, but doesn't have that same kind of visceral connection, I guess. I don't know how better to say that. It's just the information lands sometimes a little bit easier on someone who is not next of kin. It's still hard for them, but it just is a little easier for them to process it. So, yeah, we always want one or two primary contacts, at least one, two, if possible. I don't ask for three though when it comes to law enforcement, because sorry, my cat. I don't ask for three because that will overwhelm law enforcement. and they may then choose not to communicate very much. So keeping that in mind. 2 is your sweet spot. 1 is, the minimum. 2 is your sweet spot. Let them know, let law enforcement know the all the contact information for those people. So phone numbers, mailing address, and email. Preparing questions before meetings. So, like I said, if we are prepared before a meeting, you are more likely to have a law enforcement want to communicate more with family. If families get places and then they're like, well, I have questions, but I don't quite, know the answer. I don't remember all of them, things of that nature. Um, Meetings take longer, and that can discourage law enforcement from wanting to have more meetings. Keeping notes of conversations. Same thing kind of I said earlier with the 2 logs that I give, or the 2 notebooks I give families. I also have them track law enforcement conversations in there too. That way they can just know like when they last spoke with the lead investigator and what was said. And then asking for clarification when needed. That's totally fine. I actually find that it's a lot easier for families to talk with law enforcement than it is with prosecutors, because most law enforcement do use plain language when they're talking. So the information that flows between the 2 of them usually is pretty smooth. But there are still some times when things are mentioned that are a little confusing. And then follow up appropriately when necessary. So I add that in there appropriately because a lot of times with like I mentioned before, daily updates, right? That can kind of be the expectation. I want families to know that if they are emailing law enforcement, the lead investigator day after day, or multiple times a day. Not that it's inappropriate. I'm not saying that. It's just that they're not going to get a response that they want. And I don't want that to happen to them, right? I want them to feel comfortable asking questions and comfortable communicating. And I don't want them to feel like, oh, this investigator doesn't like me. And I mean, that's kind of the gist of what can happen. So I always tell families, like, let's shoot for 1 time a week, right? Maybe every 2 weeks. In the beginning, maybe once a week. Because that is something that they will most likely appropriately answer back to. So when communication breaks down, and this happens a lot, this happens a lot, because like I said, they're not obligated. Law enforcement is not obligated the same way that the prosecutor's office is obligated with families. So we want to really avoid the communication breakdown if we can, because sometimes it's hard to build it back up once it's broken. So some warning signs. So communication can be breaking down when, the clients repeatedly call and they're not getting answers, when emails don't receive responses, when families are receiving conflicting information, because what can happen sometimes is they're calling the homicide department and they'll be talking with the lead investigator. And then they'll also be talking with just a different investigator who might be there in the moment. And so you might be getting information that's not the same, which is also why I tell families, like, let's try to only talk with the lead investigator, because then you're going to get the same information that like all lines out. So if they're starting to receive conflicting information, that's probably because they're talking to more than one investigator, and one of those investigators may not be the one who's actually on that case. And they're just maybe reading notes from the lead investigator, and it's not coming across as the same. And then they no longer know who's assigned to the case. So that's also a big one, is if there hasn't been communication for several months, they call, they're not getting calls back, their emails aren't getting answered. They're wondering, is Detective Thompson still the lead investigator on this case? I don't know. Um, that does happen actually, especially in cases that take longer. And then families, will begin to feel that they're being dismissed or ignored by law enforcement. Um, and really, all those things above is what makes them feel dismissed and ignored. And that, like I said, like those are valid. Even if a family is calling every single day, it's not okay to dismiss or ignore them. I'm not advocating for that in any way. Um, it is what happens, though. So their feelings are valid to want to have that information, to want constant follow up. Very understandable. It just sometimes can become an issue with law enforcement, and we try to avoid that. And that's kind of where we can come in to soften that area a little bit. So we can, for advocacy options, we can request clarification. So if they're getting information that doesn't quite sound right, or they're getting kind of two different types of information that aren't going together, let's do a follow-up email or a follow-up call and ask for clarification. We could confirm who the assigned investigator is. Really, for us, all that is one call down to their department and just verifying, hey, I have Detective Thompson on this case. Is he still on this case? Did somebody else take over? That's a really easy one for us to get. And then we also can document all the communication attempts. So a lot of times I will have families CC me in there, like once they say, oh, I'm not getting an answer, I'll say, well, can you CC me in the emails that you're sending? Because then I can start to document those attempts. And then requesting a meeting, as soon as we see that this is starting to break down, I try to get a meeting right away. Because like I said, the sooner we could get on this, the sooner that we can clear these things up, hopefully we can avoid a complete breakdown of communication. And then if we're doing all these things, right, we're doing all our work, we're thinking, hey, we're still getting these problems. And then I would say contacting the supervisor of that department, which I have had to do before. I don't like to do, because because sometimes it can bring more bad blood and then potentially less communication still, or the communication becomes kind of ugly. But if you need to, you need to. I always tell people my job is to work for my client. It is not to make anybody else feel good. It's not for me to make law enforcement feel good. It's not for me to make prosecutors feel good, the medical examiners feel good. It's to help my client. And so if I have to, you know, talk with a supervisor because things aren't getting done in a reasonable way, then it's what I got to do. And if it brings some bad blood, which sometimes it does, and it'll sometimes bring bad blood between you and that officer. And a lot of the times, the officers for these departments, they're very small departments, so you could have bad blood with the whole department pretty easily. So, like I said, I don't want to do that, but if you got to do it, you got to do it. Um, Try to do all these things obviously beforehand. If it doesn't work, you kind of left with no choice, right? Because your job, like I said, your job is to help your client. So documentation strengthens advocacy. So this is also a big thing to do when there is that communication breakdown, because if you end up going to a supervisor, this is going to be the information you're going to want to give over to them. So we always want to keep records of any phone calls that were made with the lead detective or any of the detectives, writing down days, times, who they spoke to, and what was discussed. Those are the 4 things in the logbook that I have, and I'll share that template with you guys. And I have the template like that so that it's easy for my clients to just write it in. They don't have to remember it. Same thing with emails. It's kind of the same exact form, but keeping the log of the emails, keeping logs of meetings, what was discussed, also keeping a log of the questions that they've asked and the answers that they received, and then also documenting if that detective promised to follow up. So if they spoke with a detective at the beginning of August, and Detective Thompson said, I will contact you by, you know, mid-August with an update. I have my client write that down. And I also, if I'm included in that documentation or in that correspondence, I also document that as well. Because if we have to go to a supervisor, I want to have this all out for them to say, here's what we've done and here's what has happened, right? And it does help, one, for the client to be able to see and feel like they have power over what's happening, at least in this portion. They can visually see what is happening. But it also helps you to make a complaint later if one needs to be made. So case reflection. Maria's brother, Daniel, disappeared nearly 6 months ago and is now believed to be the victim of a homicide. During the first several weeks of the investigation, detectives regularly contacted the family to gather information and explain the investigative process. Over the past 3 months, however, communication has slowed considerably. Maria has left several voicemail messages and sent multiple emails, but has received few responses. The family is unsure whether the original detective is still assigned to the case, and no one has explained what stage the investigation is currently in. As time passes, rumors begin circulating on social media claiming investigators have stopped working the case. Friends and community members encourage the family to contact the media and publicly criticize law enforcement for failing to provide updates. The family feels overwhelmed, frustrated, and increasingly distrustful of the investigation. They ask you, their advocate, to help them understand why communication has changed and how they could request information without harming the investigation. So some of the challenges here we see are multiple calls and emails are going unanswered. The family is hearing different information from various sources. So, they have limited information from actual law enforcement at this point. Community members are having, like I said, everyone's got an opinion. It's out in the world now. So they're hearing, people from the outside giving their opinions and what they should do, going forward. The family is unsure who's currently assigned to the case. Because if they haven't heard back, it's very natural to think, well, is this person still even the investigator here? Which most likely they probably still are. They just haven't communicated. The family has not been keeping track of conversations or follow-up requests. Like I said, they weren't documenting, which is key why we want to start from the beginning. So some of the questions are, what communication barriers do you identify in this case? What steps could the family take to improve communication with investigators? How can documentation strengthen the family's advocacy efforts? When might additional advocacy or supervisor involvement be appropriate? And I will give you guys a minute.
I feel like just the documentation piece would be helpful because then you have like an organization flow of like last contact, who was it with, what was happening. And that would make it easier to advocate and also like more powerful advocacy because it's not like you're targeted back on like what information is actually missing or not being provided versus like what information did we get and like lose track of or yeah.
Yeah, absolutely. And it's that preemptive documentation, right? It's like if we do it ahead of time, we got it. We got it. And we're ready for whatever might come out of it. So yeah,
Can
we
I add
document.
something?
Oh yeah, sorry. Go ahead, yeah.
Yeah, this is sounding so familiar once again, going back to my situation. He got a hold of actually got a call from what I guess the investigating detective.
Mhm.
Uh, we were playing phone tag. Uh, he didn't call. Then I guess his lieutenant called. So we were going back and forth trying to find out information. And Actually, when he finally did talk to him, he didn't have much information. He didn't have much information. So it was one of those things where the was documenting who I was talking to, but he really didn't give his full name. He just Sergeant so and so, and whatever, and left it at that. But the the lieutenant, I got his name, but it's one of those things where you definitely have to who you talk to and whatever. But his supervisor seemed to call more than he did, which was very odd. And they got strange hours too. I found that out that they got.
Mhm.
So it's just, I guess you're right, documenting it and being a little bit aware of just how things can be different than what is, their schedule is not our schedule. The way they do things is definitely not scheduled that way, if that makes sense.
No, that's 100% true. It's when you're right. I totally didn't even mention that, but their hours way different. Way different. They're not 9 to 5ers. Some are, but very rarely. And so you will get calls at weird times. But yeah, just, you've seen that between the two, individuals talking to you is like you're getting some different information there and it's not flowing very well for you. And you just want answers, right? And so, that's where a lot of families find themselves in is like, who's in charge here? Uh, why are you not telling me the information I need to know? And, why are you not getting back to me in a timely manner? And that's very common. It's a very common situation. I say for a variety of reasons, it could be a lot of things. Sometimes it's the officer themselves just not being very good at communicating. Sometimes it's caseload. It could be anything. But I always also say, in terms of my job, I don't really, not that I don't care about their excuse, but it doesn't matter in terms of what I'm doing, right? Like my job is to get that communication flowing. So I totally will listen to their reasons of why something's happening and say, sure, okay. Um, but ultimately, like, it's not relevant to like what I need to happen, which is that I need the communication to get flowing again. And so, I keep in mind why things might be happening because I always like to give people grace, but at the same time, I'm like, okay, well, thank you for letting me know, but here's also kind of what I need for my client. So can we do that, please? And, because like I said, my job is for the client, it's not for anybody else. But yeah, I think you gave a great example, like a great personal example of seeing that firsthand, and it's frustrating. It's very upsetting. So, what communication barriers do you identify in this case? So, the family's calls and emails are not being returned. I mean, that's right there, right away. We know communication breakdown is happening. The family doesn't know who their current investigator is, which very common because I think it's very natural when they're getting the initial information from law enforcement, like the detective that's calling them, they're in immense grief. They're in trauma. They're not receiving all the information the way we would as like people who are not experiencing those things. And so it's easy to forget the names. It's easy to forget the phone numbers that are given to us, especially if we're not writing them down. Um, and so very easy for them to misremember a name or to say, oh, Detective Thompson was who called me, but, you know, Detective Colby is who called me back. And now they're confused, like, who am I supposed to talk to? Um, there are no regular or predictable case updates. So yeah, they're not getting these, at least weekly calls or not even calls, emails, right? Because you could easily do a weekly email. The family is relying on rumors instead of official information. And that happens a lot, right? Because I always tell, advocates or like anyone working with victims that when you're in immense grief, trauma, frustration, just all these horrible emotions, you naturally are going to latch on to anything that gives you hope. And I think that that's very natural for people. And so when they're hearing things that are said, whether within the community, whether it's online, if it feels like it could be the right information and it gives them hope to an answer, it is natural for them to latch onto that, and to say, oh, this is what's happening, right? And that's also kind of where we have to come in, because we want to make sure the communication's open so they're getting accurate information. Because yeah, sometimes community information could be accurate, sometimes it's not. But we don't know that. We want to rely professionally on like the accurate information. So it's very natural for them to say, I'm latching on to what I'm hearing because it gives me a little bit of answer and hope. And Officer Thompson isn't messaging me back. So these people are. So um, expectations about communication have not been clearly explained. And that also often happens. A lot of law enforcement officers do not um, have those conversations of here's my capacity to update you. And it also very similar to the prosecutor's office with law enforcement, victim-centered communication is not something that they use very regularly. Um, some officers go out of their way to learn it and to do well at it. I have met a few. I would say the vast majority that I've communicated with have not. And so, if we're talking about helping families in a victim-centered way and communicating with them in a victim-centered way, we would, as an officer, automatically set an expectation of communication with them. But that's if we were doing it in a victim-centered way. So naturally, that barrier usually develops because it's just not something that is part of what they do for their job. Although I will say a lot of them take like mandatory training on these things, but I don't think they're listening. So not been my experience. Um, so maybe one day, maybe it'll get better. But what steps could the family take to improve communication with investigators? So we would want to confirm who the lead investigator is first. And like I said, that's really a quick phone call down to that department. They should be able to give the lead investigator name and their phone number and their email with one call. And then designate one family member as the primary point of contact. Like I said, 1 is minimum, 2 is the sweet spot for having good communication. Letting law enforcement know, whoever the detective is, these are the 2 people, 1 or 2 people that will be your point of contact. Prepare questions before calling or meeting with investigators. Like I said, we always want to do that. We want to request that meeting, whether it's a lot of times with law enforcement, they tend to do phone meetings for updates. They don't tend to do in-person meetings. Some of it is for what you said earlier, is like their weird hours. So, and some of it is just, I don't know, because that's how they prefer it, I guess. But you'll most likely have a better chance of scheduling a phone call meeting with them. And then communicate respectfully and allow reasonable time for responses. This is one thing I do talk with families because it becomes very upsetting to them when they're not getting the information that they want, or it's, the breakdown of communication has happened. And especially if nobody's been arrested in the case either, they, they're heated. Also understandable, 100% understandable. It it will only harm the communication if we start to communicate in a non-professional or disrespectful manner. It will really break down that communication flow there with that officer or officers. And so I always tell families, which I get crazy emails and text messages, but send me, if you're upset, I want you to send me whatever you feel like sending me. Like if you want to just tell this person off, send me an email that you want to send them. Send it to me. You could say anything you want to me. You won't offend me. You won't hurt my feelings. Let me just let it all out. From that email or that text message, what I can do is take out what they're actually asking, right, from there. And then I set up usually, like, I'll call them the next day or that day, depending on the time that I get the email or text message. And I'll say, okay, I read your email. What I'm getting from it is you're wanting to say this. Does that sound right? And then usually they're like, yeah, or they'll say yes, and also this, you know. And so then I'll write something up and I'll say, hey, I'm going to send you this response, right? I'm going to respond to what you emailed me. Look it over. Tell me if it looks good. If, you know, make adjustments however you want to make it. And then let's see if, you know, this is what we send over. So it's a way to, one, they can get out how they're feeling to somebody who's not going to judge them or, uh, you know, I'm not going to stop communicating with them because they threw in some cuss words in an email. But also I can help them get across what they're wanting to get across in a way that will be actually received by law enforcement. Um, and then, you know, we're hoping to not break down that barrier because usually by the time we have that type of conversation happening from clients, the communication is either close to being broken or is broken because normally most clients don't start off the gate like that, right? It's because things have happened and then they're done. um, and so I'm trying to mend that communication um, link again. And it won't be helpful if we're cussing them out. So that's just kind of a recommendation that I'm giving you all if you work with any of these clients. um, be the sounding board for something if you can tell that they're having a hard time. And obviously they have to be receptive to that. If a client says, no, I don't want to do that, I'm sending it this way. I say, okay. I'm not going to tell them no. I just offer an alternative and hope that they take it because I want them to have good communication and not have it completely break down. But also at the same time, I don't tell people what to do, right? I offer suggestions, offer alternatives, and then hope that they take it. So kind of goes both ways. If they tell you no, I want to say it exactly how I've said it, and I don't want to say it however you're saying it. I say, oh, okay, well, all right, that's okay. But I do kind of warn them. I say, well, I know there's a breakdown a little bit and I don't want it to get worse, but I also respect that if this is how you want to send it, you know, you have the right to send it that way. So, you know, I'm not going to tell you not to, but sorry, went on a little tangent there. But just because you'll probably run into that quite often. And then work with their victim advocate to coordinate communication. And so that's where you also can be talking with the investigator. I always CC the client when I'm doing these conversations because I don't want to have side conversations without my client. But I will say, you know, hey, I'm their victim advocate. Just letting you know I'm here helping them. And if you don't mind CCing me in communication and you know, if you have any questions that maybe I can answer, like basically letting them know I exist because sometimes you can be that buffer that can help mend that communication gap there. That either it hasn't, the gap is there because it was never built or because it's broken down. But sometimes you can be the one who mends it. And then how can documentation strengthen the family's advocacy efforts? So we want to always keep the log of phone calls, emails, meetings, record dates, times, names of the people that they've contacted, document the questions that they were asked and the responses that they received, save copies of emails and written correspondence. I save those in my files. If I'm CC'd in anything, it's always saved. Like I said, track promised follow-up actions. I save those also in my notes for my clients. And I put little like reminders in my calendar. If a investigator said they would get back by a certain date, I have that documented to expect it by that date. And then use documentation to identify communication patterns or concerns if additional advocacy is needed. So that's where that, like I said, that documentation really comes in handy. We can buy that documentation if we start from the beginning we can see either where the breakdown occurred or whether something has happened in between. We will be able to usually see it once we're reviewing everything. And then when might additional advocacy or supervisor involvement be appropriate? So when repeated communication attempts receive no response, if they keep trying, if I've also tried and there's no response, we need to go to the next step. When the family is receiving conflicting information from different sources, so if they're getting one information from their lead detective, they've talked to another detective who's giving them completely different information, and it's just not adding up. They're not responding. Your lead detective is not just responding to you. So you've got this conflicting information and no confirmation about actual correct information. Then it's like, okay, we need to step it up and find out what's going on here. When the inside investigator changes and no new contact is provided, sometimes investigators do change. The lead investigator will change, and when that does, they don't always let you know or the family know, and so then we want to find that out for them. And then when the family has given legitimate concerns about communication that remain unresolved. So, if they have let the lead detective know, I want better communication, and they've agreed, they've promised to follow up, by a certain date, and then it's not happening, and then we try again and it's not happening, that's when we go to the next level. And then when respectful efforts to improve communication have not been successful, and when a victim advocate believes additional support or clarification could benefit the family. So, I leave it up. I think we all have good common sense. And so I say to people, it most of us, especially with working in the helping profession, we're used to having uh, good communication skills, or at least decent ones, or it'd be hard to do our jobs. We have some good common sense, and so I feel like you can usually go with your gut a little bit on this, right? Like what makes sense here rationally to take it to the next level. And if it makes sense to do that, then then go to the next level with your complaint to the supervisor. Because usually I will say once that happens is when you will have better contact with the lead detective, which you all might be why you were getting more contact from the other supervisor. They recognized the other one was not doing what they needed to do, and they said, "All right, we'll go. I'll take this over. Sit back." So, just reflection questions. How would you explain investigative boundaries to a grieving family? Kind of just thinking of some of the things that we spoke over, and thinking like, how would you, as in your own way, be able to explain those things, because it will happen that you're going to have to have those hard talks, right? And it's good to kind of prepare way ahead of time before you have to have those. What strategies improve communication between families and investigators? And I have that also there to think, because in your community, every community is different. So you might know some of your law enforcement in your community. You might know that there's better ways to communicate with them. There's better ways to reach certain people in the police department there, or the troopers. It is something that I think you, as your own, could think in your own region what makes the most sense um, for your area and for the people that you know. And then how can documentation strengthen advocacy? Um, just thinking about that, it really does. Documentation strengthens everything, in my opinion, but especially with advocacy, it really helps us, especially when we have multiple people that we're helping on our own. It is so nice to be able to look back at documentation, because we're not going to always remember everything. So even for us, it's helpful. And then what does trauma-informed communication look like during an active investigation? And it's also kind of thinking about, if you do have contact with law enforcement in your community, thinking about that, like, what does that look like in your community? And maybe even if you haven't had one-on-one contact with law enforcement about things like this, what have you heard in your community, right?
Can I ask a question if I may?
Yeah,
Um, I'm looking at what you're saying. I'm listening at what you're saying, and okay, it's like I think I said once before that usually this stuff happens outside of the community. Would the local public safety, would they know? They would know nothing about the case probably whatsoever. So there wouldn't be any reason for the family, because I know families that went to them to ask questions, but there is it's outside of here. So they wouldn't have any idea of knowing what's going on, I would assume.
yeah, I would say it doesn't hurt to ask, right?
Mm.
But you are right. They're going to have limited information because it's not their like jurisdiction,
Yeah.
you know. But also, and this is just kind of me talking, right? it it is helpful sometimes because law enforcement will respect law enforcement more at times than maybe community to law enforcement, I
Yeah.
guess.
Gotcha.
Um, and so maybe, I mean, I think it doesn't hurt to try because
So,
it
so
could,
building that rapport with the local police departments and whatnot, maybe they may be able to find out something that you may need to know and be a better gateway into that other agency if you were having some struggles or something. Because I've
yeah,
seen that work before, where I've gotten information uh, from them that I couldn't have, that I would never have gotten, but they were able to get some information and notwithstanding giving me all of the details, but giving me just enough to where I could pass that on. So I guess it
yeah,
would help to work with the local as well as something being outside of the community. So that's what I
yeah.
was just wondering about that. Thank you.
Yeah, yeah. I always recommend, especially with your local law enforcement, it's just good to let them know what you do, right? Like I'm not saying like you got to be friends with them or anything, or maybe you want to be, I don't know. But just so you like, hey, this is what I do. This is who I am in this community. Um, one, because there could be other reasons they could refer people over to the services you guys provide. But also, yeah, like that whole the respect from law enforcement to law enforcement department is usually there in a different way than it is for us. And so, yeah, you definitely might be able to get something from your local law enforcement department that you yourself might be trying to get from, let's say, the Anchorage area, and you're coming up on walls, right? But then you talk to your local chief of your department and say, hey, this is what's happening, and I've been trying, and I talked to the supervisor and I'm still having these issues. He might be able, or she might be able to make a phone call down there, and open up some dialogue that just uh, I hate to say like it shouldn't be that way because it should just we should all be professional and all be able to communicate, but it's just sadly sometimes that is what it is. It's like, oh well, if law enforcement up there is getting a complaint, I don't want to look bad down here. So I'm gonna return their phone call because I don't want them going back to this department and talking badly about us down here, and it shouldn't like that should not be the motivator for any of these departments, but sadly, like sometimes it is. So, yeah, I always recommend, especially if you're in a smaller community, it's also a lot sometimes easier to get to know those in your law enforcement department who like mainly like the detectives and like the higher ups are going to probably be your most helpful. And just letting them know, like, this is what I do, this is who I am. If I need you, I'll send you an email. If you need me, like, send me an email. And just opening that communication, ahead of time. All right, you guys, we are done. And I'm sorry I kept you 10 minutes after. Um, any questions? All right. So if you guys have anything you think of later or you just want to ask like privately, my email is right here, Cynthia@empowermentadvocate.com. So always feel free to email me. And yeah, even if you email me at a weird time, don't worry, I'll see it eventually and I'll get back to you guys. But yeah, I will see you all on Tuesday. and we will be going through more modules. I'll be putting up those modules probably by tomorrow too, so you guys can kind of look at them ahead of time.
Thank you. Have a good weekend. Bye, you guys.
Have a good weekend.
Ah.